Donald Trump made an absolutely deranged emergency filing at 1:38 a.m. to the 11th Circuit Court of Appeals. Donald Trump was demanding that he be able to continue to refer to that unlawful settlement agreement that he entered into with the IRS and the Treasury Department as a settlement agreement. You'll recall previously, Judge Kathleen Williams issued an order that the so-called settlement agreement was collusive, that it was essentially predicated on fraud, and that it could not be referred to as a settlement agreement that took place in connection with the case before her federal court, where Donald Trump sued back in January of 2026 for $10 billion. Judge Kathleen Williams said the federal case was a sham, and it was basically being done by Donald Trump, in essence, to pilfer from the taxpayers and then enter into this collusive settlement agreement. Donald Trump is now filing an emergency appeal to the 11th Circuit, saying that he wants to be able to refer to the the collusive settlement agreement. He wants to be able to say this is a real settlement agreement. He's saying that he's suffering. That's why he had to file it at 1:38. He says every day that he can't refer to what took place as a settlement agreement and in essence not pay his taxes because the settlement agreement waives his obligations basically to pay taxes from the date of the settlement agreement going back, or what it says is you can't do any criminal or civil investigations or audits into him not paying taxes. And remember, that was something that he wanted to preserve and protect, and the MAGA Republicans in the Senate basically allowed him to get away with that in terms of confirming Todd Blanche. But the federal judge in the Southern District of Florida said, this is an unlawful settlement agreement, is what she said a few weeks back. Then you will recall that in Virginia, the same group of plaintiffs who sued Donald Trump to block the January 6th slush fund, and there was an injunction issued to block that, they've amended their complaint, and they cited the prior order by Judge Kathleen Williams. And they said, look, this federal judge ruled the settlement agreement was unlawful and collusive. And she referred the lawyers of Donald Trump to the state bar for an ethics investigation. So therefore, Donald Trump should not be able to get tax immunity, and Trump's kids should not get tax immunity, and Trump's trusts and Trump's organizations should not get tax immunity based on a collusive settlement agreement. So they filed an amended complaint in Virginia federal court citing what took place in the Southern District of Florida. So then at 1:38 a.m., Donald Trump said, emergency, I'm suffering at 1:38. I kid you not. He said that he is suffering professionally right now. We need your help, 11th Circuit Court of Appeals. You need to stay and pause federal judge Kathleen Williams' order that prevents us from saying this is a real settlement agreement. We want to say it's a settlement agreement. We want to enforce it. And by the way, to all of those MAGA Republican senators who were like, oh, well, Todd Blanche, he says that he's not going to revive the January 6th fund. Well, they want to make it clear that that settlement agreement is in effect right now. That's the 1:38 a.m. filing where Trump asked the 11th Circuit, stay all further action, pause everything that the lower court federal judge Kathleen Williams is doing. And when you say, well, Ben, where do you say that he's suffering? Look at page 19. Here on the MeidasTouch Network, we look at the footnotes. We read every damn page. One of the best pieces of advice to me when I was becoming a lawyer was a law firm partner said, hey, Ben, you have to have a hard ass when you're a lawyer. I'm like, what do you mean by that? You're going to have to sit in your seat, and you're going to have to sit in an office, and you're going to have to read the damn opinions, not give your opinion, read the opinions, read the motions, read the footnotes. So let's take a look at it. This is Donald Trump's emergency, time-sensitive motion for stay of sanctions order and fee proceedings by Donald Trump, Eric Trump, the Trump Organization, and Trump's lawyers, and Don Jr. The movements, meaning Trump, his kids, the Trump organizations, are suffering irreparable harm right now. Page 19. Think about what a pathetic weasel this guy is, right? He is so terrified of Iran that he's sneaking out through catering trucks in Turkey and pretending he was on Air Force One. But look what a weak thing he is. He's saying he's suffering irreparable harm because the settlement agreement has been voided where he can get tax immunity. So now he can't get tax immunity, even though he's going to try to claim it anyway with Todd Blanche. The sanctions order is inflicting constitutional and professional injuries that no later reversal can repair. A stay will mitigate this damage. First, the prior restraint clearly supports a stay because the loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. What a freaking damn snowflake this guy is, huh? What a pathetic, weak freaking loser he is. Oh, you've infringed on my First Amendment right to refer to a collusive, unlawful agreement as the settlement. My rights are taken away. Shut up, freaking loser. He goes on to say, second, the professional sanctions on the attorneys inflict equally irreparable harm because the court's findings carry an immediate judicial imprimatur. Yeah, when you file a case in federal court, guess what happens? That's called a freaking order. It has a judicial imprimatur. It's called an order. That's what happens every day in court, you freaking losers. Mr. Brito was referred to disciplinary authorities, tarnishing his reputation and imposing career-altering consequences no later reversal can fully undo. Oh my gosh, wow. Then it goes, even my dogs are like, oh my gosh. Then it goes on to state, the public interest supports a stay of the sanctions order and related proceedings. The public interest, we're doing this just for the people. This is what the American taxpayers want. They want Donald Trump to have tax immunity. That's what the public interest demands it. The public interest strongly favors suspending sanctions orders because it punishes legal advocacy. It suppresses speech. It improperly disciplines counsel without due process. And it restricts plaintiffs and the government in future official proceedings. A stay will preserve meaningful appellate review, and prevent irreversible harm while this court considers the appeal. The American people are being harmed. Donald Trump wants his tax immunity right now, everybody. How pathetic. The public, how dare you? This appeal arises from the district court's extraordinary abuse of its sanctions power. In this action, Donald Trump, Don Jr., Eric Trump, and the Trump Organization sued the IRS and the Department of Treasury pursuant to a congressionally authorized remedy over the undeniably authorized and illegal disclosure of their confidential tax return information to the press. After reaching a settlement with the IRS and Treasury, plaintiffs voluntarily dismissed the action, which the court so ordered. After 35 former judges moved under Rule 60 to improperly reopen the case, falsely alleging fraud on the court wrongly decided that the president cannot sue the federal government in his personal capacity, and that this prohibition somehow extended to his sons, who are private citizens, and his business, which is no longer running. What do you mean his business is no longer? His sons are running the business. Dude is making billions of dollars. And the court's order isn't that you can't file a lawsuit, although no former president while they were in office would ever conceive of such a thing. It was that the way the lawsuit was carried out was clearly collusive. You filed a lawsuit after the statute of limitations where the alleged harm took place when Donald Trump was in office during his first term. So he's ultimately the supervisor of the alleged employee where the tax information leaked. It wasn't just Donald Trump's taxes. It was hundreds of thousands of other people. There is no remedy. Trump has no claim. As I said, the statute of limitations passed by years. Even if you had a claim, at most the damages are $1,000 max damages. So no, the way, and so any normal non-collusive litigation, the Department of Justice on behalf of the Treasury Department and the IRS would easily file a motion to dismiss and probably Rule 11 sanctions for the case being filed in the first place. There would not even be any conceivable concept of a settlement agreement. So when the court assessed the totality of the circumstances, the court said this was a fraudulent deal. This settlement agreement was tainted from the outset, And by the way, you all dismissed the case from me, the federal judge. You didn't alert me of a settlement. Then in the settlement agreement, you drafted the agreement by citing the case and citing the judge as though I gave you the judicial imprimatur that I blessed this settlement agreement when I never agreed to the settlement. That's what the judge said. So what the hell is this crap? And again, isn't this such loser behavior? 1:38 a.m. they're filing this. Then they go on to say, even worse, the court improperly treated the filing of the complaint as proof of collusion and bad faith, neither of which existed. The court did not deem the filing of the complaint the proof. The court deemed the way the damn case was carried out. The complaint was one indicia of it. Donald Trump suing after the statute of limitations expired on a case where the max remedy, any event, would be $1,000. But it wasn't just, oh, you filed the complaint, therefore fraud. It was how the whole behavior went down in front of the court. So just be freaking honest with what's taking place. Oh, wait, all you all do is lie no matter what all of the time about everything. The theory underlying the sanctions order is wrong. Trump sued in his personal capacity alongside his sons in the Trump Organization to vindicate their own statutory rights over the theft and release of their tax information. Trump was in office then. And this happened to hundreds of thousands of other people, and the remedy's $1,000, and you blew the statute of limitations. The IRS and the Treasury represented the U.S. separate interests. The court wrongly held that Article 2 collapsed those distinct interests into one, a fully realized unitary interest, somehow eliminating adversity altogether. No, if the Treasury Department and the IRS filed a motion to dismiss and raised the arguments that any actually practicing lawyer would have raised, maybe there wouldn't be the collusion. The court waited to see, that's what this plan was, to use my court to give the stamp of approval to this collusive agreement. Nuh-uh, the court ain't going to be used to aid and abet this behavior. Then they go on to say, long-running, illegal, and politically motivated conduct precipitated this action. And they talk about how this went down when Trump was in office in 2019 and 2020. Procedural history leading to the improper sua sponte sanctions. You know, one of the things that they repeatedly mention is they said the parties are good with the settlement agreement. The plaintiff and the defendant didn't ask the court, didn't ask Judge Williams for the remedy that Judge Williams ultimately gave. Yeah, that's why Judge Williams said it was collusive, because they should have asked for the remedy if they were non-collusive. The fact that you have Trump suing Trump suing the Trump government, where Trump controls via executive order all of the way the legal processes work from the Treasury Department and the IRS, and then they behave the way they do. Yeah, the judge is aware that plaintiffs and defendants both want to stay, that plaintiffs and defendants wanted to improperly and, as the court says, unlawfully utilize the federal court as for the trappings of legitimacy to this collusive agreement. But that's how they tried to frame this thing. It goes over here. It says, on January 29, 2026, plaintiffs timely filed a complaint. False. It wasn't timely filed. Well past the statute of limitations. On April 17th, the parties jointly sought additional time for defendants to respond, explaining they were negotiating a resolution of this action. Oh, Trump negotiating with Trump. Oh, that makes a lot of sense. That was a massive red flag right there. Why wouldn't they just file a motion to dismiss? That's what any sane Department of Justice would have done. On May 18th, plaintiffs, the Trumps, voluntarily dismissed the action with prejudice. The dismissal extinguished the claims. The court canceled the jurisdictional briefing deadline and closed the case. Okay, well, if you extinguish the claims, if the dismissal extinguished the claims, then why would you enter into a settlement agreement for extinguished claims that don't exist? How does that make any sense? Oh, wait a minute. And why would the settlement agreement reference the filing of the case and reference the court and say the settlement is in conjunction with claims that were filed? But you're saying it was extinguished. So if you have extinguished claims, what are you settling then? Doesn't this filing prove the collusion at 1:30? They're not even good at this. Doesn't the argument collapse right there? 9 days later, 35 former judges under Rule 60 moved to improperly reopen the case, alleging fraud on the court. Federal judges on a bipartisan basis allege the fraud on the court. Then they go on to say, Each of the federal court's findings of collusion, improper purpose, and bad faith flowed from a single predicate legal error that presidential supervision under Article 2 supposedly eliminated Article 3 adversary. This is wrong. Your argument is wrong. That's not what the court said. The court didn't say in every single circumstance a president can't file a lawsuit. It's odd and pathetic that you would in your individual capacity file a lawsuit, but the court looked at all of the circumstances surrounding this and said, because you engaged in this behavior, you didn't file the motion to dismiss, you said it was with prejudice, you entered into the settlement agreement, you cited the court's name, all these circumstances equal collusive settlement agreement. Oh, and by the way, who signed the settlement agreement? The signatory was actually not even Donald Trump. It was a lawyer for Donald Trump who did not even enter an appearance into the federal case, who did not even seek pro hoc vice admissions. So all of the circumstances the court looked at in a very, very significant detail. Then it goes on to say, this court entered a sweeping unconstitutional gag order binding the parties and broad categories of affiliates and referred Mr. Brito to the state bar. And it goes on to talk about how the sanctions order rests on this legal error. The sanctions order cannot stand because it punishes the movants for advancing bona fide legal positions merely because the court disagreed. That wasn't a mere disagreement. I wanted to read it all to you so you can hear the words, the specific words that Trump is saying in court at 1:38 a.m. I don't freaking care if you're a Democrat, if you're a Republican, or an independent. If you care even a little bit about law and order, then that should be a big deal to you. That should be a big freaking deal to you. This should be making you so damn livid. I hope I broke it down in a way that you appreciate. Hit subscribe, pre-order WTF America right now. We're grateful for you. We appreciate you. Shout out Meidas. Google WTF America. It's the book I wrote with my brothers, and pre-order your copy. It's by Hatchet Books. You'll see it over there. Thanks, everybody.
Before you go, our book WTF America is available for pre-order now. It's the story of how we got here and how we fight our way back. To pre-order, scan the QR code or click the link in the description. Let's do this.